I don't think we're going to get to the Freedom of Information Act today, although that would be one area where some social media postings might actually be relevant. So, some of the social media issues might actually come up today as well. But I'm Luke Mehta. I'm the city solicitor for Seaford. I'm city solicitor for other towns as well. I was previously the city solicitor for the city of Wilmington, Delaware, before we moved downstate. Also relevant in terms of my background, which might be relevant to today's presentation, I was the Chief Disciplinary Counsel for the Office of Disciplinary Counsel, which is an arm of the Delaware Supreme Court, which regulates lawyer ethical conduct. So there's a lot of parallels, and I'll draw some of those parallels for you today. I think it's a good, as the mayor mentioned, it's good to go through this not only for new members of council, but even for veterans. It's really good to do this refresher, even if you've heard it before. There's always a new angle that comes up. So that's what we will do today. I hope this is an interactive discussion. It's going to be a lot more interesting to you, hopefully more informative to all of you. The only place I might push back is if you ask a very specific question that's asking for legal advice on a very specific scenario that you have in mind, I might push back and say, look, that sounds a little too specific. Let's take that up one-to-one. But I'm very comfortable talking about these issues generally in a general sense. This is a public meeting, as it should be, and I'm very happy to talk about that in general. So let's cut right to the first topic, which is the Delaware Code of Conduct. All of you city officials, all employees of the city of Seaford are bound by the Delaware Code of Conduct, which is codified at 29 Del Code, Chapter 58. And you will see in the highlighted language, which I'll read, again, it's a public meeting, so other people can hear it as well. It's the desire of the General Assembly of the State of Delaware that all municipalities adopt code of conduct legislation at least as stringent as this state statute. And therefore, this subchapter shall apply to any county, municipality, or town, and the employees and elected and appointed officials thereof, which has not enacted such legislation by January 23rd, 1993. And because the city of Seaford has not enacted its own code of conduct, all of you and all employees of the Seaford city are bound by the Delaware Code of Conduct. So why do we have a code of conduct in Delaware? And there's a statement of policy set forth in the statute, which I think is important to listen to. It's very interesting. In our democratic form of government, let me just stop right there. It's really, in my prior role as Chief Disciplinary Counsel, the rules of professional conduct for lawyers have as their basis that phrase. We live in a democracy. In a democracy, certain principles of fairness and transparency apply. We're not a dictatorship in this country. We're a democracy. So in our democratic form of government, the conduct of officers and employees of the state must hold the respect and the confidence of the people who elect you and the people on behalf of whom you serve. They must therefore avoid conduct which is in violation of their public trust, or which creates a justifiable impression among the public that such trust is being violated. Now, this last phrase here, a justifiable impression among the public that such trust is being violated, has been interpreted by the Public Integrity Commission as the appearance of impropriety standard. You may have heard that expression in other contexts, the appearance of impropriety. We'll talk about that. But PIC, the Public Integrity Commission, which is the body that's set up to interpret, provide guidance, and enforce the Delaware Code of Conduct, has interpreted that phrase, justifiable impression among the public that such trust is being violated, as appearance of impropriety. But it's a balance, okay? So notwithstanding the need for public trust and public confidence in a democratic form of government, you all have a tough job. And we don't want to have a situation where nobody wants to serve in the role that you're serving, right? We want to encourage people to take on public service. So again, this is a quote from the statute itself. All citizens should be encouraged to assume public office and employment. And therefore, the activities of officers and employees of the state should not be unduly circumscribed. So your job is not easy. And in fact, and this will come up when we talk about recusal. A lot of you, I'm sure, I think that's one of the issues we want to talk about today. And to the extent in a public hearing, you've heard people saying, "Oh, well, you should recuse yourself. You're not impartial. You can't hear this matter." The flip side of that is you have a duty to serve. You have a duty to vote, and it's that balance that this statement is trying to get at. Your duty to serve, your duty to vote, your duty to enact legislation, but at the same time without violating the code of conduct. So again, as I mentioned, the Delaware Public Integrity Commission is the body set up by the state of Delaware to interpret, provide guidance on the code of conduct, and ultimately to mete out discipline in certain circumstances. If you go to their website, they actually have a pretty good website, and they publish synopses of various decisions that they've made, if you're really interested in it. They don't go into all the detail. They don't say the names of everybody, of course, and they sort of delete that stuff out. But they provide a pretty good synopsis of the decisions under all the categories that we're going to talk about today. That, just so you know, the PIC can, upon an investigation, at the conclusion of an investigation, they can provide discipline. They can recommend censure or even removal of a public official. And in an extreme case, which we'll talk about today, they can actually refer evidence of alleged criminal conduct to the Department of Justice. And there, as you may know, there was a high-profile case in Delaware that was based on the Delaware Code of Conduct. Let's go back to this appearance of impropriety standard. This is super, super important. As I said, PIC has interpreted that section, justifiable impression, as an appearance of impropriety standard, and they've issued guidance. What the heck does that mean? What is this appearance of this quote here on page 8 is super important, so I'm going to read it. The test is whether a reasonable person, knowledgeable of all the relevant facts, would still believe that the official duties could not be performed with honesty, integrity, and impartiality. Thus, in deciding appearance of impropriety issues, again, this is not in the statute, this is PIC issuing its guidance. In deciding appearance of impropriety issues, the Commission looks at the totality of the circumstances, and those circumstances should be examined within the framework of the Code's purpose, which is to achieve this balance I just talked about between a justifiable impression that the Code is being violated while not unduly circumscribing their conduct, so citizens are encouraged to assume public office and employment. There's one thing I want you to remember, and everybody, and including the public, to remember about this appearance of impropriety standard. It's not an untethered standard. It's not just anything that you can conjure up in your mind. Oh, it's an appearance of impropriety. It's got to tie back to an appearance of impropriety with regard to the very specific standards that we're going to talk about today. That's a super important point to remember. So there's lots of conduct that is proscribed by the Code of Conduct. I'm not going to get into all of it because a lot of it I really don't think applies to your situation. I'm going to try to focus on elements of the Code of Conduct that are particularly appropriate to municipal councils and employees. And one of them, probably the most important one in my mind, is called, I refer to it as conflicts of interest. The Code of Conduct refers to this as restrictions on the exercise of official authority. I call it conflicts of interest. It's a lot easier to remember and I think more appropriate. So here is the general standard, and we'll see in the next few slides they're going to drill down into what this actually means. But here's the Delaware Code of Conduct definition or the standard for conflict of interest. No state employee, or in your case, no municipal employee, may participate on behalf of the city of Seaford in review or disposition of any matter pending before the city in which the city employee, officer, or honorary state official has a personal or private interest. That's it. Personal or private. It's not this vague thing. It's personal or private interest. Now, a municipal official can have a personal or private interest in any number of capacities. It could be in a legislative act, so passing legislation that benefits you personally. Well, if that's the legislation, you probably ought to recuse yourself. In fact, again, this is all very high profile. I'm not disclosing confidence. It's very well covered up in Wilmington, where a legislator in Wilmington helped pass a resolution that resulted in a grant by the city of Wilmington to a charitable organization of which she and or her son was a beneficiary. Runs right into it. It comes up in other contexts that we will see today. For example, hiring decisions or review decisions. If it's a staff person, you're bound by the code of conduct as well. You can't make an acting in official capacity. You can't make a hiring decision or a firing decision or a review decision that's going to benefit you or a family member. Or in quasi-judicial acts. So we'll spend a lot of time talking about quasi-judicial acts. It's a fancy phrase, but basically it means when you all are sitting as a body to decide, following a public hearing, maybe a Board of Adjustment hearing, a subdivision hearing, a site plan review, or zoning hearing, and you're acting as a body, you're sort of acting as quasi-judges. That's what we'll talk about there. But that's the touchstone, personal and financial interest. So what does that mean? Well, the Code of Conduct tries to define that key phrase, personal or private interest, and they do so in the statute. And they say this, that personal or private interest in a matter is an interest which intends to impair a person's independence of judgment. If there's one thing you want to take away from all of this, what does personal and private interest mean for all of you? It's you want to maintain your independence of judgment. That's your job, whether you're passing legislation, making a hiring decision, or acting in a quasi-judicial capacity. You want to maintain your independent judgment, because that is what breeds confidence and encourages public trust in your decision. That's your job, to exercise independent judgment. Now, the Code of Conduct goes one step further and tries to give examples of what they mean by independent judgment. Now, this is not an exclusive list of examples, but you read the decisions, this is pretty much what I think the Code of Conduct has in mind when they're talking about independent judgment, and it's really important to keep that in mind. So let's go through it. A person has an interest which tends to impair the person's independence of judgment in the performance of the person's duties with respect to any matter when, and it's really the first one I want you to focus on, because it's quite limited. Any action or inaction with respect to the matter would result in a financial benefit. It's a financial benefit or detriment to accrue to the person, the employee or the town official, or a close relative, which we'll talk about, but spouse, son, daughter, which accrue to a close relative to a greater extent than such benefit would or detriment would accrue to others. It's a financial benefit that's going to accrue to you or a family member to a greater degree than anybody else. That is the primary definition or primary example of what the state of Delaware has in mind when they talk about personal private interest affecting your independent judgment. There's another example, which is the second bullet, which is, I think, pretty obvious, but it's a corollary of the first one. The person or a close relative has a financial interest in a private enterprise, which enterprise or interest would be affected by any action or inaction on behalf of the government. Again, they define close relative. Close relative means a person's parents, spouse, children, natural or adopted, siblings of the whole and half blood. This is a case that I was referring to. It's a very highly publicized case in this state. As I mentioned, typically PIC, the Public Integrity Commission, issues guidance, and to the extent they're going to mete out any discipline, it's in the context of a censure, maybe recommending removal. But in very rare circumstance, in fact, I'm only aware of one of them, and this is it, where they have referred what they thought was possible criminal conduct to the Department of Justice. And regardless of how you feel about the outcome of this case, and this is one of those cases where people have a lot of strong feelings one way or the other, I'm not going to get into that. I'm just going to tell you what the ultimate Supreme Court decision was, which upheld a single count. But that count was based on the Delaware Code of Conduct. So it's worth, I don't do this to scare you, it's just to provide, you need to know about it, it's just some context. So this Delaware Supreme Court earlier, this is wrong, it's not 2024, 2023, upheld the criminal conviction of the Delaware Code of Conduct, where the daughter of the state auditor was hired by the state auditor, and the jury considered evidence that, compared to others, remember that phrase, compared to others, the daughter was hired without being interviewed, was paid more than others, was permitted to work more hours, was permitted to work remotely, and received more cumulative benefits. The court said, well, the jury was presented with evidence that was sufficient enough to sustain the jury verdict on that single misdemeanor count. So let me just pause there. Any questions from anybody based on what we've covered so far?
Good.
Let's go to recusal. Now, recusal is really, when you think, it's really a remedy, right? It's the solution to avoid a violation of the Code of Conduct. So you can recuse yourself from a legislative act if it's going to result in a personal financial benefit to you or someone in your family. You can recuse yourself from making a human resource decision, maybe if it's going to impact a member of your family. And if you read the PIC synopses, you'll see time and time again that the easy solution to a potential problem under the Code of Conduct is recusal. Just take yourself out of the decision-making process, especially if you have a body like this. Plenty of other people can make the decision. But again, remember, don't recuse yourself just because you're scared. Look at the standard and only recuse yourself if you have to recuse yourself. Because on the flip side, again, you also have a duty to act. You have a duty to vote. You have a duty to decide. You have a duty to perform your job. But anyway, recusal is sort of the common request that many of you will hear about. And it comes up usually when a body is acting in what's called this quasi-judicial capacity. You rarely hear about recusal requests for just doing your job or passing legislation. You hear it a lot when there is a property interest at issue and the body is acting in this quasi-judicial capacity, a public hearing for a Board of Adjustment variance, for example, or an appeal of your building inspector's decision. Or the biggies are subdivisions and rezonings and site plan reviews. And those things can get really, really complex. They involve the application of your code, typically your zoning code, to a complex set of facts. So you're really acting like little quasi-judges. And when you have money at stake, lots of times people are trying to figure out, well, how is that body going to vote? Well, I don't think that guy or that gal is going to vote for me, so I'm going to say, I want that person out of here. He should be recused. And that's where you typically see these recusal requests. So what I'm going to do is just get a little bit into what the standards for recusal are and what they're not, because there's a lot of confusion about this. I think sometimes there's intentional confusion, but the actual standards that you should apply and the employees for the city should apply for recusal are actually pretty straightforward. Either it's because you have a personal financial interest in the outcome, that's usually very, very rare. Or when we talk about due process, which is the second part of this presentation, is if you've prejudged the outcome or you're considering facts on your own that are outside the record. Most of the other hoopla around recusal is probably hoopla and not really warranted. But that said, I'm going to go through this because there's a lot of misconfusion, and what I want you to know is when an argument has merit and when an argument probably doesn't have merit. So the standard for recusal under the Delaware Code of Conduct, as I said, is pretty straightforward, but it's not the standard. It's not the standard that judges in Delaware apply when they are asked to recuse. The judges have their own judicial code of conduct. I'm pretty familiar with it, and their standard is actually different. It's similar, but different in a very important ways from the recusal standards that should apply to municipal employees, even when they're acting in a quasi-judicial capacity. So I'm just going to spend a few minutes talking about this, not to confuse you, but rather just to sort of set it aside. There's some similarities, but there are also some important differences. So here's the judge's standard. Again, you're not judges, even when you're sitting in a quasi-judicial capacity. This is a standard, not your standard, this is a standard that Delaware judges face when they are asked to recuse themselves. It's Rule 2.11, disqualification in a proceeding which the judge's impartiality might reasonably be questioned. So I'm just going to go through these and differentiate them or compare them to what your standards might be. First, a personal bias or prejudice concerning a party or personal knowledge of disputed evidentiary facts concerning the proceeding. Just put a placeholder in that first one. We're going to come back to due process. That's very similar to the due process standard, which would apply to municipal employees who are acting in a quasi-judicial capacity. The second one, a family member is a party to the proceeding, is acting as a lawyer in the proceeding, has an interest that could be substantially affected by the outcome of the proceeding. Well, that's getting pretty close to the code of conduct standard that we just talked about if the interest was a personal financial interest that would impact the person sitting on the board or that person's family member. The third one is the closest to the applicable standard for municipal employees or council people. A judge has an economic interest. Remember that phrase, that personal financial interest? The judge has an economic interest in the subject matter, in the controversy, or in the party proceeding, or any other interest that could be substantially affected by the outcome. And I'm not going to belabor this, but if you ever hear somebody trying to ask for one of your all's recusal and they cite Los versus Los, everybody loves to cite Los versus Los. That ain't your standard. That's the standard for recusing judges. And we can go through it. I don't want to bore you on this. This is not your standard. It's similar to what we talk about in terms of due process, but it's not the Delaware Code of Conduct standards. So if you hear people talk about Los versus Los, tell them to go back to law school. I'm going to skip over a few slides just in the interest of time. Any questions so far? So we've talked about conflict of interest and recusal. So the next big bucket is things of monetary value. Things of monetary value. And I really want to focus your attention on the second half of the quoted section of the Delaware Code. Second half. No state employee, well, in your case, no municipal employee, municipal officer, or honorary municipal official shall accept other employment, any compensation, gift, payment of expenses, or anything of monetary value under any circumstances in which such acceptance may result in any of the following. So you got to go to the next slide. So acceptance of a gift by itself is not a problem, but it could be a problem if it results in any of these things on the next slide. And I really want to focus on the second and third bullets. An undertaking to give preferential treatment to any person. Short version of that is taking a bribe. You know, that's pretty obvious. Next bullet, making a government decision outside official channels. Well, what do you think they mean there? And I think the most common example, which again, if you read the PIC synopses, you talk about maybe it's a city council person trying to go behind the scenes and trying to influence a staff person's decision outside of official channels, inappropriately but on the base of having received something of monetary value. And the final one, any adverse effect on the confidence of the public in the integrity of the government of the, in your case, the city. And here, this, again, the synopses from PIC seem to suggest that here what they're really talking about is that the size of the gift is just so big. It's like, oh my God, I mean, you got tickets to the Masters? I don't think so. You know, a cup of coffee, that might be okay. Tickets to the Masters? I don't know. That's so big that, again, it's going to affect the public confidence in your all's independent judgment. There's some common fact patterns. Again, all of these are not hard and fast rules. If you read the synopses, they're all case-specific, fact-specific. But some of the standard scenarios under which things of monetary value are reviewed by the Public Integrity Commission include tickets to fundraisers, payments of conference fees, vendor payment of meals, accepting honoraria, and solicitation from private companies. So that is, so we've talked about conflicts, we've talked about recusal, gifts, exorbitant gifts that might impact your independent judgment. There's some other prohibitions in the Code of Conduct that I'm not going to spend too much time on. I've listed them here. You have the slides. But again, let's just focus on bullets 2 and 3 here. Because sometimes I think people don't think about these. Other prohibitions under Chapter 58, specifically 5806, using public office to secure unwarranted privileges, private advancement or gain. You might want to, in your notes, call this abuse of power. This is really an abuse of power prohibition. And the next one is interesting, and I think a lot, you know, it's worth reminding ourselves of this in the context of municipal government, because I don't think that people realize that they can run afoul of the Code of Conduct here. If you are in the possession, or if any employees in the possession of confidential information that belongs to the city, including privileged information, and you disclose that in an unauthorized way for your personal benefit, you may be in violation of the Code of Conduct. And then the final bullet, which, you know, in today's world, you know, we don't want to be too prurient about this stuff, but it comes up in almost every single Code of Conduct, whether you're a lawyer or a public official. It comes up time and time again, using or granting sexual favors as a condition, either explicit or implicit, for an individual's favorable treatment. This type of prohibition, again, exists in virtually every Code of Conduct, regardless of profession. Finally, in addition to the ones listed here, there are a couple others. And again, for any of these items that we've talked about today, we're not going to get to FOIA today, but if you want me to come back and drill down on any of these, please just let me know offline, and we'll come back at a later time to talk about. But again, without going through all of them, you should also be aware that there are other restrictions under 5805, which are not listed here, but I'll just mention to them briefly. Contracting with the state, so if you have an equity interest in a company and that company is engaging in a financial transaction or contracting with the city, that's obviously something you want to be careful about. There's an absolute prohibition under the Code of Conduct for a town official or a town employee to be representing another private interest in front of the town. Should be self-evident, it seems to me. That's why we don't spend a whole lot of time on it. And then, of course, post-employment restrictions, typically for most, well, the Delaware Code of Conduct says if you're working for the state and you go out into the private sector, there's usually a 2-year prohibition on appearing before the state, or in your case, before the town. But it's not in general prohibition. It's got to be related to a matter on which you work personally and substantially. Okay. Again, I can drill down on that if you want, but those are the general propositions. So let's talk. I've talked a lot about due process, which really goes beyond the Code of Conduct. The Code of Conduct defines the standards to which you are held, and recusal is the remedy for most potential violations. But again, when city employees or city officials are acting in what's called a quasi-judicial capacity, Board of Adjustment decisions, site plan reviews, subdivision reviews, zoning code decisions, rezonings, I should say, rezoning hearings, following a public hearing, this issue of due process comes into play. And again, people love to tout due process as something vague. It's very narrow in the context of judicial or quasi-judicial decision-making in the municipal context. Just some background. So, as I mentioned, the Code of Conduct provides guidance for financial, what I'll call actual conflicts. There's also this other body of law regarding constitutional-based conflicts of interest. When I say constitutional, I mean due process, fundamental fairness, notice and opportunity to be heard. That's basic fairness is a simple definition of due process. And even though a particular set of facts and circumstances may not suggest an actual conflict, the same facts and circumstances may nevertheless prohibit the affected individual's participation of a perceived conflict. And again, this rarely comes up in the legislative context, because in the legislative context, when you're passing bills, you're passing resolutions, or just doing the job, it's an actual conflict, this personal financial interest standard, which is really quite narrow and pretty clear, that comes into play. But it's really in this quasi-judicial capacity, which is sort of an adjudicatory capacity, that this due process standard comes into play, again, in certain contexts that your town is engaged in. So let's just cut to the chase. There are two cases that often get cited here. They say it's the same standard, but one is a Cherno versus Folsom, and there's also a case on the next slide regarding against the city of Wilmington, but it's basically the same standard, and this is the Delaware Supreme Court that has articulated the due process standard for public officials acting in a quasi-judicial capacity, so I'll just read it to you, pretty important. A public officer acting in a quasi-judicial capacity is disqualified to sit in a proceeding in which there is a controverted issue as to which he or she has publicly expressed a preconceived view, bias, or prejudice. Preconceived view, bias, or prejudice. Such officer must disqualify him or herself if he or she has prejudiced the case or has given a reasonable appearance of having prejudiced it. It is fundamental that a quasi-judicial tribunal, like a court, must not only be fair, but must appear fair. Again, this appearance of independence standard. Let's just drill down on those two things very quickly. This is the site to the other case. So there are really two examples. If you look at the due process cases in the context of municipal quasi-judicial decision-making in Delaware, it's really two things. Prejudging the outcome. And what does that mean? It's where, again, from the standard that was quoted from. Some of you may, before you sit in a quasi-judicial capacity, maybe you've been involved as a member of the public, or maybe just an interested party, or maybe you tweeted something on social media, or spoken at a public hearing. And you didn't realize it then, but then you realize it a month later, or 2 months later, or 6 months later, and suddenly now you're sitting in this quasi-judicial capacity. And 6 months ago, you sent an email to the city, you spoke in a public meeting, and you pretty much said, I'm opposed to this thing. Well, if you're opposed to this thing as a private citizen, but then 6 months later you're acting in a quasi-judicial capacity, that could be a problem. And that's really what we're talking about here. When municipal officials act in a quasi-judicial capacity, again, think Board of Adjustment, think site plan review, subdivision review, rezoning hearing, public hearing, the debate, the decision, and the deliberations need to be in public, and they need to be formed at the conclusion of the public hearing based on the facts that actually are in the record at the public hearing. not based on some preconceived judgment that you had 6 months ago, but based solely on your deliberations and your decision after the public hearing. And this is where your typical request for recusal will come from, which actually has some merit. The other one, which gets less attention, but it's also in the due process cases, is the consideration of evidence or facts outside the record proceedings. So, and it's tough, especially for some smaller jurisdictions where everybody knows everybody, and you're sitting in a quasi-judicial capacity, and the property at issue happens to be your neighbor, right? So it's hard to dissect your personal impressions of your neighbor when you're also sitting in a quasi-judicial capacity. The key here is to be honest with yourself and with the public that the people who are acting in this capacity are basing their decisions on the record that's actually presented during the hearing, rather than going off and doing your own private investigation outside the hearing by visiting your neighbor and cross-examining your neighbor, but then not bringing that to the attention of the tribunal. This second prong can be undone. There's some suggestion that you could sort of wiggle your way out of it by saying, look, yeah, I did it, I'm sorry, it's a small town, hard to dissect that, but I'm going to just focus on the facts in the record. There seems to be some latitude. Prejudging the outcome is a problem. And I'll finish up and open it up to some questions by this balance between what's called the member of the public versus the quasi-judicial capacity. So a perceived conflict is separate and distinct from the off-site of participation as a member of the public. Again, all of you are citizens and residents of Seaford. Restated, even if an individual is permitted to participate in a particular process as a member of the public, he or she can still be disqualified from future processes due to a perceived conflict of interest. So it's not a per se bar. You can participate as a member of the public and then subsequently sit on a quasi-judicial board, but you need to be careful, as I mentioned. And I'll finish on this issue with this statement, that Delaware law does not prohibit officials from participating in processes simply because the individual is a town official when there is no actual or perceived conflict. I've always thought, so I'm a lawyer, I was head of disciplinary counsel, and I used to teach ethics at Delaware Law School. And on the issue of conflicts, I would always tell my students this. I said, you know what? If you don't understand conflicts, you're going to be turning away good business. Like, if you don't do your homework, you say, oh my God, there's a conflict, I can't take this case. Well, that's kind of silly because you're turning away a good case. It's always telling me to figure it out. Figure out what the conflict standards are so you can take cases that you can take, but don't take cases that you can't take. And I think the same concept sort of applies here. If you actually look at what the actual code of conduct standards are, what the actual due process standards are, I think you can reach this balance between doing your job, voting when you have to vote, deciding when you have to vote, while at the same time not running afoul of the code of conduct. So I think I'll pause there, and happy to have some Q&A rather than starting FOIA, which is probably going to be a 45-minute discussion unto itself, and I know you have other things to talk about this evening.
Are there any questions from council? How about the public?
I have one.
City manager has it.
So, Mr. Mehta, you talked and you went through extensively on the Delaware Code of Conduct, specifically calls out recusal in the language. And there is a distinct difference between recusal and abstention, correct? Yeah. Abstention is you sitting here or me sitting here and not voting. Recusal means removing yourself from the entire proceeding, correct?
Yeah, that is correct, and that not participating in the hearing, not participating in the deliberations, I mean, that means
Could you
just.
maybe put a fine point on that distinction and the reasoning behind that?
Yeah, so what I would say is this, we just went through the standards for recusal, which really means taking yourself out and removing yourself from the deliberation process. Abstention, I think, is a loosier, goosier phrase where people, I think, invoke it because they don't really want to vote in favor, but they don't really want to vote against. They just they're not quite sure, and they just not comfortable voting. I think abstention doesn't have an ethical component. It has more of a component of being unsure or indecisive.
Is it true that in certain circumstances when people have chose abstention, they can still be accused of influencing an outcome by their mere presence in and among the decision makers?
So if they're simply abstaining because they're indecisive, then I don't think there's any problem with participating in the deliberations. However, if there's a code of conduct or a due process problem which calls for recusal, then the individual should remove him or herself from the deliberations so they're not accused of influencing the outcome.
And by removing, you mean step out of the room?
Yeah.
You leave completely.
Yeah.
Yeah.
Just want to make sure that's
And,
clear.
and just a hypothetical, if we had someone who, I'm trying to think of the law that you went through very, very adeptly talks about if you stand to have financial gain. But is there a minefield out there where if the company I work for stands to financially gain, I should really consider recusal in a situation like that?
So I think there was one slide where I mentioned if you are representing another private enterprise before the city,
Yep.
That's certainly a problem. And if you're acting on behalf of the city with respect to a company in which you have an equity interest, partnership interest, a shareholder interest, an ownership interest, that is a problem under the Delaware Code. But if you're simply an employee and you're not getting any stock options from the company, I don't think the Code of Conduct addresses it. Now, there may be, depending on your seniority in the company, if it's significant enough that in essence you're acting on behalf of that entity, then again I think it's a problem. But if you're just one of thousands of employees and you have no equitable interest or equity interest in the enterprise, I don't think it's a per se problem.
Thank you.
Would that also apply for nonprofit?
Yeah, I think so. And I think the issue with nonprofits has been not so much that you're familiar with nonprofits, but where municipal officials have gotten into trouble is where they have awarded grants, municipal government grants to a nonprofit, in which the public official benefited by virtue of that person's role in the nonprofit. But if you're simply a fan of the nonprofit or just a member of the nonprofit, then you're not getting any financial interest. I mean, really, the Code of Conduct is pretty narrow. People don't like to say that, but I'll say it. It really is pretty narrow. Personal financial interest is the touchstone for you or a family member.
Other questions? I definitely think we ought to have city solicitor back to go over for you at some point.
Absolutely.
That is such a tricky trail, and we certainly have gotten our experience over the last 10 years caused by Mr. Henderson, but
Yeah, I mean,
not
it's,
even a smile on that one, but
I really think to start it and stop after 10
Right.
minutes would be
well, it's
silly.
it's
Yeah.
been tricky, and we've learned along the way. We're pretty good now, but I think with new council people, I think FOIA is an important part to understand and what it can be.
I'm happy to come back whenever you like me to, and hopefully you found this to be helpful. The slides are
Absolutely.
yours, are
Fabulous.
public slides, and happy to do any follow-up on a one-to-one basis.
Yes. to
Okay.
recess.
All right, yes, so if there's no other questions, I'll take a motion to recess until 7 o'clock.
So moved.
Motion from Councilman McCoy, is there a second?
I'll second.
Councilman Henderson seconds. All those in favor say aye.
Aye.
Those opposed, case unanimous. Thank you.